Right now, we are standing by for those closing arguments to begin in the murder trial for Megan Boswell. Let's bring back in criminal defense attorney and former head prosecutor Bob Bianchi, who is standing by. We're waiting for everything to get going there in Sullivan County. Bob, the defense didn't put on a case. They are waiting, really. This is their moment to shine in front of this jury.
I wouldn't put a case on either. I know I have a contrarian view here. I was on court TV a number of times yesterday talking about this. Having been a homicide prosecutor, and that's how I'm looking at this, okay? So I don't want to offend anybody. You know, maybe the jury comes back with the guilty here. But based on the forensic pathology and the testimony that came out, where the government has to prove beyond a reasonable doubt that this was a premeditated murder, they could not tell the jury what the cause and manner of death was. They could say the words that the cause and manner of death was homicide, but the two forensic pathologists got beaten up really badly. They were not good witnesses. It was nothing but guesswork, and on multiple occasions indicated that it could have been natural causes and other things. Now, premeditated murder means that you purposefully or knowingly caused the death here. They presumed the baby found in the trash can was murdered in the trash can, as opposed to maybe something happening to the child outside. And look, it's true that the defendant lied many times. And as homicide prosecutors, we were very cautious with this because there's lots of reasons people lie about things. Maybe it was malfeasance. Maybe it was negligence. Maybe it was somebody else. She's 19 years old. She didn't do the right thing. The bottom line for me as a prosecutor, if I was listening to my forensic pathologist be cross-examined like what happened yesterday, I'd go home and have to take a Xanax. This was not a good look for prosecutors. Now, maybe they'll get over the hump because of the mere magnitude of the crime itself, but it wasn't a good day for them. And last point, I recently just had a homicide case dismissed because of sloppy forensic pathology work like I saw yesterday on TV in this case. And it took us 4 years to get the experts that eventually the government had to relent and say, you know what, this wasn't a nefarious act by the defendant, but rather the baby died of natural causes, but we jumped to conclusions and didn't do all the proper testing. And ultimately, thankfully for my client, he's not going to spend the rest of his life in jail. I couldn't help but think about that analogy of that case when I was listening to what I will characterize is the most incompetent pathological testimony from a forensic pathologist that I've heard in my legal career or my career as a TV legal analyst.
Let us know what you really think.
That example, Bob, from your own career.
Right, but it's going to come down to what the jurors in the box decide.
Very true, and we understand that the state is about to start their closing argument. Let's go in live.
All right, that was an interesting way to end that direct. Let's bring in our guest still watching with you at home, Bob Bianchi. Bob, where do you see this cross-examination going?
You got to be careful with this kind of cross-examination. This witness is obviously important to the state's motive evidence, and as we always say, motive is not an element of the offense of murder, but as a former homicide prosecutor, you sure like to have it so that you can put the crime into context for the jury. As a defense attorney, cross-examining a witness like this is going to be very difficult because, in my mind, a lot of the information she provided on direct examination is rather irrefutable. I don't think there's going to be a contentious cross because you got to worry about upsetting the jurors that you're beating up on a witness. And the bottom line is you're not going to get this witness to really move away from the opinion about drug use and the custody battle. These are all things, not the drug use so much, but the custody battle that is in the record. It's just the argument isn't here for the defense. So I'd imagine when I cross-examine as a defense lawyer or when I was a homicide prosecutor and people would cross-examine family members, they typically went pretty gingerly and pretty easy unless there was a clear indication that individual was lying. I don't think we're going to see that.
Now there's an objection from the defense because we've been going on and on with this witness, nothing from the defense, but they don't want to get in that connection, that overlap.
Right.
Let's bring in our guest to see what he thinks about this moment. Criminal defense attorney and former head prosecutor Bob Bianchi is with us. Bob, not only do I want to get your reaction to this moment there where she may be showing that connection between John Mello, the father of the child that her sister had, but also the fact that the defense hasn't given this jury anything really to think about as they're hearing these witnesses because they didn't do an opening statement.
Yeah, I want to take the latter question first. I mean, on a tactical move, at least in my state, we're not allowed to defer opening statements. Prosecution goes first with its opening, and then the defense is allowed to give an opening. They can waive that, but they don't get an opportunity to come back and do an opening at a later point in time. In states where this is done, typically speaking, at first, when I first saw it, I didn't think it was a good idea because I always believe in the idea of primacy and recency. That's how we're taught as trial lawyers, that the things that are said first and the things that are said last are the things that typically jurors will remember. And that is why, guys, and I always love being on your show and talking about how to construct a trial. As prosecutors, we would always start with our most impactful evidence first and last, and in the middle, kind of squeeze in all that kind of stuff you have to present, but isn't really critical to the case. So you wonder, did the defense make a mistake in not being able to position their theory of the case before the jury? Or is it better, and I guess they chose this option, to wait to see what the state's evidence is and then elect afterwards to do the opening statement? And at that point in time, they feel that that would be the best tactical move. So I really believe it's an interesting dynamic. I just can't see myself personally deferring an opening statement, having tried so many cases, knowing the importance of, if not anything, establishing my credibility to the jury, my relationship to the jury, so that they can hear my words, so they can hear me talk about the burden of proof and where it rests and the importance of listening to all of the evidence before coming to a conclusion. With respect to this particular moment, it's hard to really say exactly what's important and not important because we don't know where the defense is going with the case. So again, sometimes you don't object if you don't think it's going to affect the theory of your case. We'll have to wait and see as to whether or not these decisions in the end were the smart ones.